This podcast is brought to you by the School of Advanced Study, University of London. All of our podcasts are available from our website, www.sas.ac.uk.
Human rights between Australia, Canada, New Zealand and the United Kingdom. I understand that this evening he's going to focus particularly on one of those jurisdictions, but if you have questions on those other jurisdictions, Stephen's very kindly agreed to take questions on those other areas. So Stephen, over to you. Thank you very much.
Thank you very much, David. Thanks to all of you for coming today, and it's a pleasure to be here, and I thank David and the Institute for the invitation to come and present this material. I guess I should start out with a disclaimer, and one of the areas that I used to practice in was consumer protection, and we always used to talk about misrepresentation and pursue cases along those lines. So I apologize if I misrepresented what the presentation would be about, since it included New Zealand and Australia in the preliminary materials. The reason I have focused more, or will be focusing more, on Canada tonight, and maybe I'll stand up because that's important. Thank you. You're welcome. The reason for the focus on Canada is that the project I'm working on now is a long-term comparative look at 5 common law countries and the impact of international human rights treaties on asylum jurisprudence in domestic courts in those countries. So how domestic courts utilize, interpret international human rights law in domestic cases that involve non-citizens, people fleeing persecution from other countries. The countries that I chose, and for a variety of reasons that I'll get into in a bit, are Australia, Canada, New Zealand, the UK, and the US. Primarily because at least 4 of the 5 of those, and you probably know which is the 5th, have shown a willingness to refer to or rely on international human rights law in their asylum jurisprudence. The United States is the outlier in that regard. But in starting to work on the database and putting together our analysis of the cases, and starting with Canada, it became clear that Canada is a very interesting case on its own, and that it was also going to be quite labor intensive just to work on the Canadian cases and to analyze all of them. And also to keep this presentation relatively short so everyone can go out to dinner within a reasonable time, I think we'll just focus on Canada instead of worrying about the other countries tonight. So, but as David says, by all means, if you have questions about the other jurisdictions, I've started the research on them. I've interviewed lawyers in each of the 5 countries. The most complete database in terms of cases, as you'll see in a bit, is from Canada. We've looked at some cases in the other jurisdictions as well. Okay, so by the way, what we'll do is we're going to keep the lights kind of high so you can see things while we just have text. I've got some graphs and charts later on, and we'll turn the lights down lower so it's a little bit easier to see, particularly in the back of the room later on. So what are the key questions that I'm looking at in this study? There are really 3 of them. The impact of international human rights treaties on asylum law in domestic courts in common law countries. And again, the idea here is that asylum, or the right to claim asylum, is a creature of international human rights law. The Refugee Convention of 1951 established that. And then what happened is countries around the world incorporated that treaty into their domestic law. And so it's up to domestic courts to decide whether or not an individual, a non-citizen, is entitled to asylum in that particular country. And they have to meet certain requirements. The basic one being they have to show that they have a well-founded fear of being persecuted in their country of origin on the basis of 5 grounds. Race, religion, political opinion, social group status, and nationality. Okay? So in other words, when do these international human rights treaties help asylum seekers, and when might they actually hurt them? Because what I found in particularly with some of the interviews that I've done in Canada and elsewhere, is that some of the lawyers feel that in certain situations these treaties can actually prove counterproductive for their clients. And there's certainly a theoretical aspect to this, and I'll get to that in a second in terms of some theories on the effectiveness of human rights law. But then there's a practical aspect also in terms of how lawyers who represent asylum seekers might make better use of human rights treaties on behalf of their clients. When does it make sense to invoke them? And again, when might it hurt? Why pick Canada? All right? A few reasons. It is one of the most popular destination countries for asylum seekers around the world. 600,000 applicants for asylum since 1990. It has a widely regarded reputation for respect for immigrants and for human rights generally. There was a Migration Integration Policy Index that came out, it comes out periodically, came out last year, ranked 3rd among 31 Western countries. By way of means of comparison, the US ranked 9th and the UK 12th. This is in sort of a whole range of statistics about how welcoming and accommodating a country is towards folks coming from other countries. Number 1, by the way, was Sweden, and number 2 is Portugal. Okay, also, Canada, relatively economically prosperous, which I think is important because it would indicate that if courts are reticent to apply international human rights law in asylum cases, it must be for reasons other than financial instability. Now, when I talk about treaties, what am I talking about? Okay? Because, of course, we have the Refugee Convention. That's a treaty, but of course that establishes the right to asylum in the first place. So that's not one that I'm considering. I'm also not considering the Convention Against Torture, which of course is a very important treaty for people fleeing persecution. But the Convention Against Torture contains the substantive right to not be returned to a country where you're likely to be tortured. So that, by definition, has a strong impact on the lives of asylum seekers in domestic courts. I'm looking at treaties that don't protect asylum seekers per se, but have been used by lawyers and in some cases upheld by courts as helping asylum seekers. So the 5 here, the Covenant on Civil and Political Rights, that can be used sometimes. For example, if someone is fleeing political persecution in their country of origin, the argument that they will make to the court in Canada or elsewhere is, if you return my client to his or her home country, Canada will have violated its obligations under the Covenant on Civil and Political Rights, which includes the right to be free from harm as a result of political opinion, etc. Convention on the Rights of the Child, another one that is fairly typically used. The typical scenario there is that if an asylum seeker otherwise fails to meet the definition of asylum or fails to meet the requirements, the argument is, well, if you return the person to their home country and they have a child who's a Canadian citizen, then if you return the parent, that's going to harm the family, it's going to harm the child, and therefore returning that parent to their country of origin is going to violate Canada's rights, Canada's obligations, under the Convention on the Rights of the Child. The others are the Convention on the Elimination of All Forms of Discrimination Against Women, sometimes invoked in cases involving domestic violence, where women are seeking asylum on the grounds of being a victim of domestic violence in their home country. And then the last 2, not used as much, and so my research mostly has focused on the first 3, but the other 2 I've listed here are the Covenant on Economic, Social, and Cultural Rights, and the Convention on the Elimination of All Forms of Racial Discrimination. Canada has ratified all 5 of these, but has not incorporated them into its domestic law, okay? Which is an important distinction, because one of the debates about the effectiveness of international human rights treaties is, are they effective simply because they're ratified, or do they have to be incorporated? Does the state legislature, in fact, the legislature in that country, the national legislature, have to adopt the treaty as part of its domestic law? So again, all 5 of these ratified by Canada, but not incorporated into its domestic law. Okay, the theoretical frames for the research, and what theories do I hope to build on, and in some ways critique as a result of this study. There's at least 3 of them. One is, and I'm paraphrasing here, but the human rights law matter. In other words, do they have an impact? The human rights treaties have an impact on state actors, or are they just sort of fluff that countries feel good about signing, but they really have no intent to abide by? And there's been a lot of research on that. But there's generally two schools of thought. One school of thought, Una Hathaway is one of the proponents of this, is that they really don't have much impact at all, and if they do, they're often unintended consequences. On the other hand, Beth Simmons, Catherine Sickink have a more, I'd say, optimistic view, and feel that at least under certain circumstances, treaties can have an impact and do have a positive impact on state actors, and state actors will comply with treaties, again, under certain conditions. The data I've collected so far suggests that the true impact of treaties, again, at least with respect to asylum law, and these studies look at treaties in a variety of contexts, but in the asylum law context, the truth lies somewhere between these fields. That is, that they do have an impact. It's not an all or nothing thing, but it depends on a variety of circumstances that I'll get into a little bit later. Then another theoretical frame is the human rights approach to asylum law. James Hathaway and Deborah Anker are proponents of this. The idea here is that the protection of refugees is best pursued through reliance on ratified human rights treaties. Okay, ratified human rights treaties. And that the idea is that advocates should invoke human rights treaties, ratified human rights treaties, as often as possible. And what that will do is it will lead to the diffusion of human rights throughout the world. State actors will be compelled to deal with it and presumably comply with it as long as advocates, NGOs, others continue to press state actors to comply. And my preliminary findings, or what I found through the data that I've collected so far, is that it's not such a positive sum game, that there are some situations in which lawyers who advocate on behalf of clients in asylum cases and invoke human rights law, many times it has no impact whatsoever, and there are some cases where it can actually be detrimental to their clients. Cause lawyering is a field within socio-legal studies. It's the study of lawyers who advocate not only on behalf of individual clients, but on some larger cause. We often call them public interest lawyers. And basically groups or lawyers who are advocating for marginalized individuals or groups. There's been a lot of writing on cause lawyers who invoke human rights law on behalf of marginalized communities in the developed world. Very little work about cause lawyers who represent marginalized groups or individuals, non-citizens within developed countries. And so asylum is a great way to build on that theory. There is one study that looked at UK lawyers who represent asylum seekers, a series of interviews. There, the finding was that because the stakes are so high in asylum cases, because obviously if you lose, your client's going to be sent back to a country where they're likely to be persecuted, they will make human rights arguments all the time because even when they think the judge is going to be not receptive. Again, my finding is that it's a little more nuanced than that, based on the lawyers that I've spoken to, and that they're aware that there are some situations where it may not be a good idea to invoke a human rights treaty. I'm going to talk about that a little bit later. Okay, so those are the three theoretical frames. So what I'm working towards is an integrated theory of the impact of human rights treaties. The thesis is there are several circumstances on which the impact of these treaties depends. The first two I've collected data on, and we'll look at that, particularly the first, in terms of whether or not the treaty has been integrated either formally by act of the legislature or informally. And by that I mean and there's a couple of examples of this in Canada, if a court or an administrative agency has sanctioned the use of that treaty as an interpretive tool or a guidepost that decision makers should use in evaluating whether or not someone has a valid asylum claim. If you have that kind of informal integration, then that treaty is likely to have an impact. The country of origin of the applicant is something we've just started to look at. that may have an impact or an influence on the impact of the human rights treaties. The other 4 are things that we're going to be looking at. The nature of the asylum claim, I mean, that's in a way that's rather obvious. For example, again, a claim based on domestic violence, the Convention on Discrimination, or the Elimination of Discrimination Against Women, is likely to have more of an impact for that kind of a claim. Ideology of the judge. There are studies in both the US and Canada suggesting that female judges are more likely to grant asylum than male judges. And so by the same token, one of the things I'm going to be looking at is whether or not female judges are more likely to rely on international human rights treaties in deciding an asylum case than are male judges. That was the gender, I'm sorry, ideology. Okay, ideology, there have also been studies showing that conservative judges are less likely to grant asylum than more liberal judges. And therefore, one of my hypotheses is that more conservative judges are going to be less likely to rely on or refer to human rights treaties in deciding asylum cases than are more liberal judges. And then the gender of the applicant may play a role as well. There was a study in the UK about a decade ago, and there's a study in Canada suggesting that female applicants have a slightly better chance of getting asylum than do male applicants. So one of the things that I'll be looking at is whether or not, in cases involving female applicants, whether the judge might be more likely to cite, to refer to, rely on a human rights treaty. Okay. What are the methods that we use? It's really a 2-part method, one involving coding of asylum decisions, written decisions, either by asylum tribunals. The way the asylum system works in all the countries that I'm looking at is that the initial decision is made by an administrative tribunal, not a court. But in many cases, those administrative decisions are written, so we can analyze them. And then eventually, some of those cases are heard by appellate courts, particularly if the asylum seeker loses at the administrative level. So we look at those decisions as well. We've looked at cases in Canada between 1990 and 2010. Why did we pick that period? Really 2 reasons. All the treaties that we looked at had been ratified by Canada by the late 80s, so that gave us, that suggested a 20-year period. Also, the 20-year period gives us a long enough period of time against which we can view any trends in terms of the usage and the references to these treaties. The second part, so we had we've coded about 2,000 cases. Then I've held interviews with about 20 Canadian lawyers who specialize in asylum law, and there aren't many more than that. It's obviously not a huge money-making endeavor, as you might imagine. Most asylum seekers cannot afford private attorneys, so it's a rather small group, which lends itself, frankly, to a lot of communication between those lawyers, as you might suspect, a lot of sharing of ideas about strategy, including the use of human rights law in their advocacy. All right, how did we code these cases? We looked at each of the cases. And after looking at several of them, we decided on 7 codes. And again, this is coding the way that the court referred to or relied on one of those 5 international human rights treaties. So I should say that obviously the vast majority of decisions that we looked at made no reference to these treaties at all. Okay, there were about I think about 20,000 written asylum decisions within that period. About 2,000 included some reference to the treaties. Okay, so again, we're talking about a relatively small subset of all the asylum decisions. So first, did the court rely on the treaty in rendering its decision in favor of the asylum seeker? This is the most helpful category. Here the court's saying, yes, this treaty is relevant, and in fact it's because of this treaty that we're granting relief to the applicant. That's the most helpful. 2 is kind of the opposite. 2 is, the court is saying, it doesn't say because of this treaty we're denying your client asylum, but it's saying that we're rejecting your argument that the treaty is relevant. Okay, we find that your treaty argument is not valid, so we're rejecting it. Third is another helpful category because the court uses the treaty to buttress a decision it's really already prepared to make, but it sort of helps it reach the ultimate decision. So it isn't the crux of the decision, but it's supportive. Another somewhat helpful reference is where the court uses or cites the asylum seeker's home country's violation of the treaty. You know, as you may know, when you litigate asylum cases, one of the things you have to do is you have to present the court with reports about the conditions in that country. Okay? And so you say in country X, certain tribal groups are discriminated against, or press freedom, freedom of the press is non-existent, women are victims of domestic violence in huge numbers, etc. So sometimes the court will use one of the treaties, will cite one of these treaties in explaining why it is that, or explaining what's going on in the home country and why that serves as a basis for the asylum seeker to obtain asylum. The fifth one, the treaty is referred to in a dissenting opinion. That could be helpful, that could be not helpful. 6 is that the court says that the destination country, that is the country where it's sitting, doesn't recognize the validity of the treaty. And then the 7th is the court mentions the treaty, most likely because the lawyer advocating on behalf of the client mentioned it or invoked it, but doesn't analyze, basically ignored it. Okay? Doesn't really pay it any heed at all. This was referred to many times as lip service. 6 and 7 really were, the lawyers that we interviewed, they say, well, courts will give lip service to these international human rights treaties, but they won't give them any real weight. Okay, some of when I would interview lawyers, talk to them about their use of the human rights treaties in asylum cases, the factors influencing that use, whether they felt that the treaties helped or hurt them. And then also, some of the questions were designed to get at the issue of case versus cause. In other words, did they ever perceive a conflict between advocating on behalf of their client and utilizing the human rights treaty on behalf of their client, but also advocating for the larger cause of the diffusion of human rights? And did that larger cause sometimes get in the way of the rights of their client? And so that's the other thing that we were looking at. Okay. Oops. Just by way of background context, I think I should start. I might want to turn the lights off at this point. I think we're getting to the charts. You can see them. I realize it may be hard for the folks way in the back to see the numbers on the bottom. I'll explain it. This is really, again, this is contextual. This shows you the progression of acceptance rates, or basically successful asylum cases in Canada over this 2-decade period. Generally a decline. Okay? Even though Canada has a reputation as a welcoming place for asylum seekers, you can see that while in the early 90s it was well above 50%, now it is hovering just over 40% in the last several years. I've asked several Canadian lawyers for the reason for this. The most commonly cited reasons are that in the last few years there have been a larger influx or an increase in applications from asylum seekers from Mexico and Roma applicants. And what's happened is that the government has come out, the immigration minister has said that asylum applicants from those areas are not legitimate refugees. Just came out and sort of made a blanket statement about that. The feeling is that that impacted some of the judges, and they started ruling accordingly. The other factor is that the judiciary has grown more conservative, or has become more conservative in Canada because of some of the appointments by Prime Minister Harper over the last few years. And again, because of the research I indicated earlier, as that shows, more conservative judges are less likely to grant asylum. to give you a little bit larger context in terms of some of the other countries I'm looking at here, the dark line is Canada. The green line, interestingly enough, is the United States, which used to be way below Canada, down around 20% in the early 90s, but has gone progressively up and actually surpassed it in the mid-2000s. And before I became too proud of that, someone told me, well, that's because in the mid-1990s, there was a major Immigration Reform Act passed in the United States, which weeded out a lot of the weaker claims, first of all, at a very early stage where there was no decision at all, but also acted as a deterrent to people even filing for asylum, such that the pool of cases remaining were stronger. They had a better basis. So that means, as a matter of course, that there's going to be an increase in the grant rate. Australia and New Zealand are interesting. Again, we just got this data, so I haven't had a chance to ask any of the lawyers in those two countries about it. Both, hovering quite a bit lower for a while, although each one gradually edging up over the last 2 decades. Okay, so that just gives kind of a comparative context. Okay, so this graph shows the total references to any of those 5 treaties by tribunals and courts in Canada over the last 20 years. All right. Now, the big spike is in the Convention on Civil and Political Rights. Spiked way up in the mid to late 1990s and has gone precipitously down since then. The other increases, I realize yellow is probably not the best color choice. Yellow is the CEDAW, or discrimination against women. Also rose in the late 90s, not nearly as much as ICCPR, and has gone down somewhat since then. And then Convention on the Rights of the Child, which is the green arrow. The other two, social and cultural rights and racial discrimination, barely referenced at all, and that's why I just have not included them in this analysis. Now, as to why we see these spikes in the 3 treaties, kind of particularly in the late 1990s. First of all, overall, we can attribute it to what was described to me in several interviews with lawyers as a concerted effort by Canadian refugee lawyers to include human rights arguments in their advocacy. So this is the way that lawyers actually have an impact on the shaping of the law, because they put arguments based on human rights treaties into their briefs, into their oral arguments, and in a sense they force the courts to deal with them one way or the other. So it's found its way into asylum jurisprudence by virtue of the lawyers, really in a sense as a concerted strategy, because it is a relatively small group, strategy or form of advocacy. Okay, the blip for the Convention on the Rights of the Child, or the increase in the late 1990s. Whoops, sorry. Attributable, I think, to a case called Baker versus Canada. Pivotal case in the Supreme Court of Canada, which held that even though treaties that have not been incorporated into the domestic law of Canada are still important and or courts need to be attentive to the values and principles underlying those treaties in making decisions. And so in the context of the Convention on the Rights of the Child, which calls on member states to consider the impact of any state action on the best interest of the children, in Baker involved one of the situations like I referred to earlier, where the removal of the asylum seeker would result in the splitting up of mother and child, and the court held that was not in the best interest of the child, so it granted relief to the mother. And so Baker set that precedent, after which we saw, and you can see in the graph, many cases where the CRC was referenced in the decision. By the same token, the Convention on the Elimination of Discrimination Against Women In the mid-1990s, the IRB, which is the Immigration and Refugee Board in Canada, that's the tribunal, issued guidelines on women refugee claimants fearing gender-related persecution. So women claiming asylum because they've been the victims of domestic violence in their homeland. The IRB guidelines say that in deciding those, they're guidelines for advocates, for lawyers, but also for judges. And it explicitly says that in deciding a claim based on domestic violence, courts and lawyers should look to CEDAW or that treaty in determining whether or not someone is entitled to relief at domestic court and is entitled to asylum. So that obviously had I believe it resulted in an uptick in references to the treaty after that. That huge spike, we go back for a second, the red one, again, we got hold of this data not long ago when we finished coding, and in the process of asking lawyers in Canada, what do you attribute this to? And haven't heard back yet. So there, as far as we know, there is not a seminal case or administrative guideline or anything else to explain that spike, at least the increase and then the precipitous decline after. Okay, but this helps to lead to part of the theory that I'm advancing, that this sort of informal incorporation, courts or administrative agencies sanctioning the use of a treaty by courts is an important factor in dictating the impact of these treaties on state actors. Okay, so now what I'm going to do is show you a series of slides, mostly pie charts, some graphs, where what we did was they show the result of the coding for each of the treaties, and then in 5-year blocks. So we have a 20-year period, 1990 through 2000, and what we did for illustrative purposes is we divided into 5-year periods to show trends in terms of how the courts are referring to or otherwise utilizing these treaties. And again, we're gonna focus just on 3 of the treaties, the 3 that are most frequently referenced. That is the Convention on Civil and Political Rights, Convention on the Rights of the Child, and CEDAW, or Discrimination Against Women. Okay, so we'll start with the total chart, okay, or the total number of cases, 1,268 cases. So and as you can tell from that, the earlier chart, ICCPR is, over the 20-year period anyway, the most frequently cited treaty. Okay, how do courts reference it according to that coding? Well, as you can see, the majority, it was in a not helpful way. It was relied upon or referenced in denying asylum in more than half the cases. Okay, in the whopping 3 cases was it relied upon in actually granting asylum. Okay, so really the only way it was particularly helpful is the green, which is in buttressing a decision, again, in favor of the applicant, but it wasn't the main reason that asylum was granted. But it was a make-weight. It was helpful. Okay? And then the other large category is that it was simply ignored by the court. Now what's interesting is that, again, this is for the entire 20-year period. What's interesting is when we look at the progression. Okay, this is the first 4 to 5 years. As you can see, the number's not that high. In the early 90s, there weren't that many references to the ICCPR or any of the other treaties. They're relatively new. Lawyers haven't started that strategy of utilizing them at that point. Okay, but you can see it's almost 50-50, more or less, between the non-helpful red and the more helpful green. That is the buttressing of decision in favor of the asylum applicant. As we move later in that decade, the proportion of not helpful decisions stays more or less the same, but now we begin to see the yellow slice, which is the judge ignored it. Okay, whereas the green slice, where it's buttressing decisions in favor of the asylum applicant, is starting to shrink. And sure enough, that trend continues in the early 2000s. Okay, again, the percent, now the N is getting a little bit bigger, the percentage of cases where the reference was not helpful is about the same, but judges seem to be ignoring the treaties with greater regularity. And by the same token, using them to buttress a positive decision, less so. And then that trend continues even more dramatically over the last 5 years. Okay? And then the next slide just shows, it's kind of a summary of this progression. What we've done is, the colors here refer to the years, 5-year periods, 90 to 94, 95 to 99, 2004 to 2004, and 2005 to 2010. And then we just divide it according to the 7 coding categories. So again, the point here is that, for one thing, references generally to the ICCPR have declined after a peak in the mid-1990s. And again, we saw that same trend in the earlier chart with the spike for ICCPR. Okay? But again, the vast majority of these references are in a negative sense. They are either referenced in a case where asylum is denied, that's the second category, or ignored in the decision, which is the 7. Okay? And yes, occasionally, it has been used to buttress a decision granting asylum, but with the exception of that spike in the mid-1990s, the percentage of those, or the amount of those cases has gone down. Okay, so that's the ICCPR. Slightly different scenario with respect to the Convention on the Rights of the Child, and my hypothesis is that's because of that Baker case that I referred to earlier, the Supreme Court case. So here we have the CRC, Convention on the Rights of the Child, and this is again the 10-year total. Now the N is smaller. This is a treaty that's not referenced nearly as much over those 20 years as ICCPR, but enough to make some conclusions. Okay, and the major conclusion is there's B in this pie, there's blue in this pie, and there's no blue in the one for the ICCPR, and that's because there are at least some cases, and a significant number of cases, where the Convention on the Rights of the Child was used by the courts and relied on by the courts in granting asylum. Okay, so the most helpful way that treaties can be used. It's also a sizable proportion, sizable green slice here. That is situations where the court used the treaty to buttress a decision in favor of the asylum seeker. That again, that had reached on other grounds, but uses it to support it. But again, more than half of the references are in cases where asylum is denied. Okay, so how does the CRC break down according to the 5-year periods? We weren't even sure whether we should include this slide because the N is so small, 4, so hence the very even proportion, so you kind of ignore this one, not very helpful. It gets more interesting here. Okay, because as I mentioned earlier, Baker was decided in 1999, and so we start to see, that's why we've got, the N is still relatively small, but we've got a portion of blue. That is, Baker is the precedent now for courts being able to rely on the Convention on the Rights of the Child in granting asylum. Okay? But again, about half of the references are in cases where asylum is denied. Now as we get into the 2000s, we have the appearance once again of the yellow slice, that is courts starting to ignore the treaty altogether. That is, the lawyers make the argument, it's mentioned in passing in the decision, but the courts don't make any mention, don't rely on it, don't reference it at all in the decision, don't analyze it. Okay, and here you can see the blue slice. If we look from here to here to here, the blue slice is getting smaller in terms of the percentage of references that are helpful in the sense that the court's using them as the basis for a grant of asylum, whereas both the red and the yellow are growing over time. Okay, so here's the graph kind of summarizing the Convention on the Rights of the Child. And here, unlike the ICCPR, references to the Convention on the Rights of the Child have generally increased over the last 20 years. Okay, And again, I think that's attributable to the Baker case. But again, most of those references are in a negative way, either in cases denying asylum, and also when the treaties are ignored in a decision. Okay. And finally, the Convention on the Elimination of Discrimination Against Women. So the total number of cases here over the 20-year period is 282. And again, pretty even split between the helpful and the not helpful references to the treaty. But as you can see, there's no blue slice in there at all. Never relied upon in granting asylum. So in that way, it's similar to the Convention on Civil and Political Rights, which suggests that whereas the Baker case, which was a Supreme Court case, led to a greater usage of the Convention on the Rights of the Child in subsequent cases, with CEDAW, those guidelines published by the Immigration and Refugee Board seem to have not much of an impact at all on the courts in relying upon CEDAW in granting asylum to applicants. Okay, if we look at the progression here, again, a very small n in the first 5 years. Okay, what's interesting here is, unlike either the Convention on the Rights of the Child or Civil and Political Rights, we actually have a majority of helpful references, at least references where CEDAW was used to buttress a decision in favor of the asylum seeker. But this, as you can see, as with the other treaties, begins to change as we get into the 2000s. So suddenly, again, we have the appearance of the yellow slice, where the court or the tribunal is simply ignoring the human rights argument that the lawyers are making. And I mean, again, we'll go back from 2000, 2004, and then 2000, whoops, sorry about that. Right, there we go, okay. So from there to here, we have the yellow slice is increasing in terms of the judges ignoring those arguments, and the green slice, the buttressing of decisions in favor of the applicant, has declined. So again, here's the summary of the progression with respect to the Convention on the Discrimination Against Women. Again, like civil and political rights, virtually no cases where it was relied upon by the court in granting asylum. And like ICCPR, the percentage of helpful cases has, or helpful references, has been going down over time. Okay. Now, what we decided to do after we saw this data, we thought, well, this is pretty interesting. So let's analyze or separate those 7 codes, or at least 6 of the 7, into the helpful and not helpful categories. Okay. So what we did was we took the codes dealing with situations where the court relied on the treaty in granting asylum, that was the blue, buttressed the grant of asylum, that was the green, cited in a country condition analysis. There weren't very many cases like that, so we didn't, it's not that significant, but we put that in there because those are situations where the reference to the treaty is helpful to the applicant. And then we got the not helpful categories. That is, that's the red, the reference in the denial of asylum, or if the court said, this country doesn't recognize that treaty, so we're not going to, it doesn't have any impact. Or the yellow, where it was noted, but it wasn't analyzed, or it was out and out ignored. So we grouped those together. The only category that's not up here is when it was used in a dissent, and there's so few of those, and that doesn't divide as well between helpful and not helpful. Because what we wanted to track was, well, what's happened trend-wise over those 20 years in terms of how helpful or not helpful these treaties are. Because again, the assumption in much of the literature, both in terms of the human rights approach to asylum, but also in some of the cause lawyering literature, is that these treaties and invoking these treaties is always helpful to the asylum seeker, and our data is showing that just isn't the case. Okay, so we combined all the treaties and all the helpful and non-helpful references, so over 1,900 decisions. And what this shows is that the percentage of not helpful decisions has been increasing over the past 10 years, while the percentage of helpful references has been declining during the same time period. So they started out 60-40, and they are now more or less at 80-20, not helpful, helpful. So there's certainly more references to human rights law in treaties. Judges, again, are being forced by advocates to consider these arguments. But what seems to be happening is that those references are having a less and less helpful impact on individual asylum cases as time goes by. Okay, then what we did was we broke this up into the 3 treaties. The findings are somewhat similar. This is ICCPR. This is very similar to the chart for all 3 treaties combined. Similar trend here. The CRC is interesting because in the 90s, actually, the helpful references went up. And again, that's right after the Baker decision. And there was a spike in helpful references in the late 90s, but that has now gone south, whereas the unhelpful references have increased, and again, are up to around 80% of all cases that reference this particular treaty. And then maybe the most intriguing diagram is this one with the Convention on the Elimination of Discrimination Against Women, where there are actually more helpful references to CEDAW, again through the late 90s, perhaps because of those guidelines that were issued and the way that they were used by courts, but that has now reversed itself, and we have, again, many more non-helpful references in asylum opinions than helpful. Okay. Then we've started to look at country of origin, because remember when I talked about the possible factors that can influence an asylum or the impact of human rights. Since we had these helpful and not helpful references, we thought, well, is there a disproportion? Are certain countries sort of over or underrepresented in cases where there are helpful or unhelpful references? And what we found, again, this is preliminary. We're still looking at this, but there's a couple of conclusions that we've been able to draw, and that is, if you're an asylum applicant and you're from one of these countries on the left-hand side, you are more likely to receive sort of a helpful, or the decision involving your case is more likely than if you come from other countries to contain a helpful reference to one of the treaties. On the other hand, if you're on one of the countries over on the right-hand side, you are less likely, the decision in your case is less likely to receive a helpful reference to one of the treaties. Now, we could probably spend a lot of time thinking of all the geopolitical reasons why these countries are on either side of the frame here, but anyway, that's the result of our preliminary findings in terms of country of origin. So country of origin, as I stated in the hypothesis, does seem to have an impact, or it does influence the impact of human rights treaties in individual cases. Okay, so to wrap up, what are the conclusions that this data and the interviews that I've done so far suggest with respect to Canada? And of course, it'll be fascinating to see whether these conclusions apply to the other countries as well. And obviously, I welcome your thoughts, your own conclusions about what this data might reveal, or any questions you might have. First of all, we have kind of an erratic pattern of references to the treaties. Okay, Some have, reference to some treaties have generally increased over the last 20 years. That is the Convention on the Rights of the Child, discrimination against women. Others have actually declined. We had that real big spike in the Convention on Civil and Political Rights, but then it has precipitously declined since then. So there's no overall pattern, although just generally speaking, there are more, there's certainly more references, generally speaking, to human rights treaties than there were 2 decades ago. All right, more interesting conclusions, though, is most of these references to treaties are not helpful. Okay, they occur in cases in which asylum has been denied. That's important because, again, the assumption in much of the literature in this area is that treaties, international human rights treaties, will help asylum seekers. That's simply not the case. And in fact, based on the interviews that I've done in Canada, in some cases it can hurt. It can hurt in cases in which the judge is predisposed against international human rights treaties. They think they're soft, they're fluffy, and that if you make an argument that's based on them, particularly if it's a key part of your case, then that must mean that you've got a weak case, and the judge will be more inclined to argue, to decide against you. And that has come up in several interviews. So there are many situations in which lawyers are making the decision not to invoke human rights treaties because they think it can work against their client. And that this majority is growing. That is, the majority of cases being not helpul. The cases where treaties are referenced being not helpful is growing. Okay, as you saw from the red and the blue lines in those recent charts, the decisions in which a human rights treaty was referenced and asylum was denied has been steadily increasing, while the proportion of helpful references has declined. And then whether treaties are helpful to asylum seekers depends on a variety of factors. Again, whether the treaty has been integrated into domestic law, either formally through a legislative enactment, as with the Convention Against Torture, which is part of the domestic law of Canada, or informally sanctioned by a high court, such as the Baker Court did in the Convention on the Rights of the Child. Okay, and that case led to the blue slice, the cases, the subsequent cases where courts were using the Convention on the Rights of the Child to decide in favor of the applicant. And finally, the country of origin of the asylum seeker may have an impact. It may be more likely to be helpful to applicants from China and Iran, less likely to be helpful to applicants from Mexico and Pakistan. That's still very preliminary. The country, we have to look at that more, but that's at least the preliminary finding there. That is it. Thanks for listening, and I welcome your comments, suggestions, criticisms, etc.
Good. Well, thank you very much.
Fire away.
Okay. Well, I suppose a few things to say first. First of all, that these kinds of studies I think are really quite rare, and there's something about the quality of the data which is really puts across some fascinating trends in the asylum caseloads. And that's data that I've not often seen for countries. I don't know how easy it is to get hold of that kind of data in Canada. I can think about the challenges one would have in the UK, and they would be quite considerable. So this study really does help to shed some light on an area where existing studies are quite rare. And I think the conclusions themselves are pretty startling, really. The idea, certainly whilst I was in practice, is that human rights law is a jolly good thing. The more you use it, the more one might be able to push the boundaries of protection of refugees, etc. Now, I do think that in this study and more generally in those sorts of theories, that there is a need to unpack the idea about what's helpful and unhelpful. Are we talking about pushing the boundaries of refugee law? Or is there an element about potentially unmeritorious cases getting through? That might be one of the critiques which is advanced. A couple of observations just while perhaps people are gathering their thoughts, and I'm sorry if I'm covering the floor here. In terms of the spike in the 1990s, one possible explanation for that might be a case called NG versus Canada, which was heard in the Human Rights Committee sometime, I think, in the 1990s. You can correct me on this or check it out later. But that was the first case that was heard under Article 7 of the ICCPR, which is the prohibition on torture and human degrading treatment. And it was the first case using the ICCPR to suggest that where torture or inhuman degrading treatment was a foreseeable consequence of removal, that the ICCPR Article 7 would prevent removal, and that was a case against Canada. So it might be that within lawyerly circles within the government, the implications of that filtered through. If that doesn't fit, then I'm at a loss to explain it as well. It's certainly an interesting trend. It would be really interesting, I think, also to look at the UK's removal of its reservation to the Convention on the Rights of the Child in respect of immigration matters a couple of years ago. And I think that probably just about falls within the scope of your study if you go up to 2010. There's been a lot of case law about that in the various courts recently. There's another study which we actually had presented to us last year in this same series by Helen Lambert. And she's very interested in how judicial practice in one jurisdiction impacts on judicial practices in other jurisdictions. And I wondered if you picked up anything within your study on Canada about whether Canada had been influenced by the use of human rights law perhaps in the UK or in other jurisdictions, or whether vice versa, whether Canada led the trend in that respect. And lastly, I'd be interested whether you noted in your study, whether you're able to differentiate these variables. When you talk about the use of human rights law treaties, whether you noticed whether they were used with respect to particular elements of the refugee definition. Were they used with respect to inclusion, with respect to exclusion? Within inclusion, were they particularly referenced on, for example, protection by the home state? Or was it to define what political opinions might be? So I just wondered, just while people were gathering their thoughts, if you might be able to speak to a couple of things.
Sure. Yeah, those are great points. Yes, with respect to the judicial practices from one jurisdiction influencing the other, several attorneys did mention that, and also non-attorney advocates in this area, and that Canadian courts frequently look to, particularly Australia and the UK, for guidance on these issues. So that's definitely an element of this that I'll be looking at, and have not looked at the whether they're used with respect to certain parts of the refugee definition, which is a great point. And we've thought about it with respect to different types of claims and how certain treaties would have more of an impact with certain claims, but looking at the refugee definition and the impact, and that could be another variable that we could look at. It's a good suggestion.
Good, thanks. Okay, any questions from the floor? Comments, observations? Yes.
Yeah, thanks very much.
Yeah.
I had a few questions. I mean, one of them actually followed from David just said about sort of linked to this idea of the court relying on human rights treaty to reject asylum, and I was wondering whether it was really relying on the treaty to disprove one of those elements of the refugee convention, so as to say the ICCPR proves that there was no persecution based on political opinion, but sort of two things that link to that is, A, was the court, or were the courts using human rights treaties to deny the claim based on sort of a counterclaim made in the course of the case by the government? That is to say, was the government using the argument made by the asylum seekers, lawyers, and saying, no, actually, if you look at that treaty, it proves otherwise? Or was it an independent judgment made by the court based on the strengths or rather weakness of the case put forward by the applicant? So that's one element. The other element, which I think is interesting, sort of when you link the different charts, is whether there was a degree of intersectionality in the claims. So whether there were cases where the asylum seeker was trying, the lawyers were trying to invoke both, say, CEDAW and the ICCPR because there were elements that would fall under those two treaties, and whether you can see in the same case the court accepting an argument regarding one case and not regarding the other. I may be complicating the charts, but these are just sort of two initial observations that I had looking at this, because it is quite interesting, the disparity.
Yeah, those are great points. In terms of unpacking or further analyzing how the courts are actually, what they're basing their rejection of the human rights argument are. Mostly what we found is it's the former, it's the court either relying on what the government has said in terms of denying the argument, as opposed to just sort of coming up with the argument on its own. One of the things, though, that's difficult to get at with this kind of a study is how frequently, we're assuming that in most of these cases it is the applicant's attorneys who are making the arguments. But of course, it's, you know, you can't get the briefs that they file in every case to know that. But again, in talking to the lawyers, it's very rare for the courts just sort of sua sponte to say, oh, you didn't make an argument based on the Convention on the Rights of the Child, so we're gonna invoke that and rule against you on that, or whatever, or say that it doesn't apply. So I think it's fair to assume that when the arguments show up in judicial opinions, they're because the lawyers for the asylum seekers mentioned that. But in terms of the intersection, the cases where they raise both, that's a good point. Yeah, it would probably complicate the charts and complicate the coding in the database and everything. But although what we did do is, if it turned out that they considered two arguments, and maybe this wasn't clear in the data, we could make that clear. So when n equals 2,000, it may not be 2,000 different decisions. It might be 1,950 different decisions, but 50 of them had two different treaties considered in the case. So it really n is really references to treaties, not necessarily independent case decisions. So that's probably an important distinction to point out. So thank you.
Yes.
I have a question regarding going back to your end point.
Yeah.
In the beginning, you said that it was 2,000 out of the 20,000 decisions that you looked at.
It's about 20. I'm not exactly sure the total. Yeah.
When you were mentioning the spikes and discussing how many references there were along the age, would that kind of reflect that similar percentage vis-a-vis the general total of decisions, or not?
Yeah, that's a good question. In other words, yeah, were the total number of applicants, or total number of applicants, or total number of decisions up in that time? I'm not sure, and that's a great question, and that's certainly worth investigating. It's easy to find out. We can code and figure out when the decisions themselves were made. Yeah.
And the other question is, when they refer to human rights instruments vis-a-vis the situation in countries of origin, would they also refer to, for example, UPR reports, etc., from the country of origin, or would they kind of step only to the reference to the treaty itself?
Yeah, it was just to the treaty itself that we focused on. Yep. Yeah. Good. Yeah.
Yeah, thank you very much. It was very interesting, slightly disconcerting. But I was wondering, I appreciate you had a short time to give us your presentation, but I was really curious and anxious to see an example of where it had been used detrimentally. And I also wondered if you looked at the quality of their analysis of the convention, because certainly, as David was saying here, they're beginning, since the reservation was lifted on the CRC, we're starting to see judges consider best interests and things like that, and I wouldn't say that their analysis is very good all the time. So even if they use it detrimentally, it doesn't mean they've done it right. And then I suppose the follow-on question from that was, I wondered in how many cases, if it was relied on in a particular, really crux point in the case where it was ignored, how many of those go on to be taken higher appeal and judicial review?
Right.
And do you look at that?
Yeah, we have not. in terms of, you know, which of the codes result in judicial review, and that would certainly be interesting to look at as well. As far as the quality of analysis, it's hard to look at it in any systematic way. I'd say anecdotally, on the basis of interviews, and of course, I suppose lawyers who are acting for advocates for asylum seekers may always disagree with decisions against their clients. But one of the things that I hear a lot in all the countries where I've interviewed lawyers in each of the 5 countries is that a lot of the judges they just don't understand the treaties, and so they are misapplying them. And that gets to another point. You know, even if faced with some of this data, which again is new, so it's not like we've talked to the lawyers. It'd be interesting to do another set of interviews with the data. Well, partly to say, well, how would you explain this? And I also say, even if this is true, even if everything that you say is true, that doesn't mean we should stop including the treaties in our advocacy, because, and several lawyers talked about, you know, beating the dead horse or continuing to do it until the judges get it right. And they said, sometimes I feel like I'm beating a dead horse when I keep invoking this. But the hope is, among a lot of lawyers, that eventually they'll get a case like Baker, right, where the court sees the light or whatever, and says, yes, this treaty, they interpret it correctly, or they say this treaty has meaning and should be used as an interpretive tool, or it should have an impact in determining whether or not somebody is entitled to asylum. So yes, you might lose the battle for your particular client, but that gets into the larger cause of, well, you have to have 10 defeats before you get a victory like Baker, and that seems to be what informs a lot of the strategy of the lawyers that I spoke to. So, you know, that's something that we'll certainly look at and analyze in terms of at least the lawyers' analysis of the quality of the judicial activity.
Yes.
So thank you very much for your talk.
Yeah.
Definitely very insightful, very interesting for me. I was also looking to clarify a bit more about the cases in which the use of international human rights law instruments was either unhelpful or in fact harmful. And apart from the variables that you found in the study, what do you think about perhaps the burden of proof under international human rights law being higher than, say, under the 1951 Convention definitions of refugee? Do you think that plays into the cases that in which asylum is not granted?
Yeah, thank you. Further examples of where it's unhelpful. I think, and your question kind of got to that as well, I think, in terms of when is it used in negative cases. Again, it's not that the judges say, we're going to deny your claim because of this human rights treaty, but they'll at least address the argument. And so there'll be a political persecution argument, and the lawyer has included a claim under the ICCPR. The judges will analyze it and just say it doesn't meet the burden of proof, or it doesn't meet the threshold. In terms of where it's harmful, again, that is more, that's harder to codify in terms of the database. That comes more from the interviews with the lawyers, where their impression is that it can be harmful to the client if it's raised before a judge whom they know is predisposed against human rights laws or human rights treaties, and will look at the client's claim more adversely because it has those claims, and will just think it's frivolous because it's oh, here we go, here's another claim under the CRC, and it could actually weaken that lawyer's argument. Yeah, the burden of proof, that's a good point. I don't know if that plays into this. It's certainly worth thinking about. I mean, the burden of proof for asylum seekers is high, even under the convention. I mean, I tell my students before they go to court on behalf of our clients that, unlike most of the cases, or at least, in theory, there's a level playing field when you're in civil court. I don't think there's even a pretense to a level playing field when you're representing asylum seekers. The assumption is that they're lying. and you have to prove otherwise. So it's much more than a 50-50 proposition. And maybe even higher when you're talking about human rights. Maybe, again, I'm basing this on some of the comments that the lawyers made, because of this pejorative view towards treaties, at least among some members of the judiciary. That's not real law. It's kind of fluff. And so that makes it even harder to succeed on those claims.
Okay, yes, right at that.
I found the really interesting, especially the country of origin aspect right at the end. I know from my own personal experience, practical experience as well, that certain groups, I mean, this may be a UK thing, but they denied visas into Canada. I mean, especially if they're from a certain group, like the Ahmadi Muslims. They're from Pakistan generally. And I don't know whether you came across that in your study, and also the Iraqi Christians as well. They obviously have to have the religion on the passport, and they denied visas, say visit visas, study visas into Canada. So the general consensus is that yes, Canada is very welcoming, but to get there, it's better to swim rather than getting a plane. So did you come across anything like that in the study?
Yeah, great question. Again, the country of origin piece of it we just started looking at, and so all we have so far is, and we've been able to look at, is what country they are. So we haven't been able to dig any deeper in terms of religious affiliation or anything else. So the answer to your question, the simple answer is no, but we will look into it more deeper, because I think there's a lot there. Both some of the categories that you identify, and obviously some geopolitical reasons for that in some ways also underlie why it's easier for people from some countries to gain asylum than it is for others.
Yes.
I just, as someone who knows very little about law or any of these issues really, it seems that this sort of downward interest or reverence towards international treaties in the last 10 years or 20 years seems to reflect for me in a sort of a cultural, in my cultural setting, a rising irreverence towards the United Nations, international treaties, international law in general. And I wonder, this other sir at the table brought up sort of cross-jurisdiction analyses, judicial analyses. And I'm just wondering, is there a relationship between, not only between jurisdictions, but between areas of law within one jurisdiction, their sort of compliance with international treaties? So for instance, between migration and environmental law within any given country. Do you know what I mean? And I wonder if it would be sort of an interesting analysis to see if at any given moment in the last 20 years, if there was a similar interest or respect by the judiciary in international treaties across different areas of law. Does that make sense?
Yeah, it does. Raises a couple of interesting issues. And I mean, first of all, that's one of the things that would be really fascinating to look at when we put in the other countries into this and see do they have that same general decline, which would speak perhaps to the communication between the judiciary, which there's a lot of, and there's an international association or an association of international judges, whatever it is, that does communicate on these things. On the one hand, you would think that would lead to some greater respect or appreciation for international treaties, but at least this data suggests that may not be the case. In terms of other areas of the law, again, I don't know the situation in these other countries. I mean, certainly in the U.S., it's interesting, right? Because right now you have, over the last decade, you have a lot of pronouncements by people like Justice Scalia, right? That this is our law and we don't need help from anybody else to help us interpret it. And so there's that U.S. exceptionalism. kind of thing. And I think that certainly pervades. I mean, look, if I showed you, talk about the little n that made some of those pie charts ridiculous. I mean, that's basically the whole U.S. Study over the last 20 years because they just don't reference these treaties at all. On the other hand, you do have some cases, Lawrence v. Kansas and others, where judges in the U.S. are starting to look towards, but that's more about international law and international norms, and it happens sometimes in cruel and unusual punishment cases, death penalty cases, where some of the judges are starting to look at international practice or international norms and striking down certain practices in the death penalty context. Other areas, commercial areas, it's certainly worth looking into. I don't know that same kind of exceptionalism argument plays in, because there it's private parties abiding by treaties of treaties of the sea or environmental treaties, commercial treaties, that sort of thing. But all this is certainly worth looking into, and again, once we get the databases from the other countries going, it'll be fascinating to see if we see some of the same trends, particularly over the last decade, which really is trouble, I have to say.
Okay, I'm going to say 3 last questions. Is that okay?
That's fine. Sure.
Okay, 1, 2, 3.
Just quickly about what you have found now in Australia and New Zealand in relation to what you're doing for
Yeah, sure. The Australia and New Zealand parts are most, I've done interviews in both those countries. We just started to collect the data, so there's just not enough to draw any conclusions in terms of these trends. By reputation, New Zealand is a much more welcoming country for refugees than Australia is. Australia resembles more the U.S. in terms of its attitude towards refugees, I would say, although that other chart showed that the U.S. acceptance rate is increasing. But New Zealand, part of the phenomenon is they have a drain brain issue, as they call it, and so they want to be welcoming because they're afraid that some of the best and brightest are leaving for Australia, frankly. So, but they're starting to get. It's interesting, actually. While I was over there last summer, you always hear about the boatload of refugees trying to get to Australia and being held on Christmas Island and all of that. New Zealand, until last summer, hadn't had that problem. And then one boat that was rejected, I think it was Sri Lankans, was rejected by Australia, kept sailing towards New Zealand, which also rejected it. So they may start having the same issues. In terms of the lawyers' attitudes, what's going to be fascinating is that New Zealand has, when we talked about incorporation, New Zealand has incorporated more of the treaties into its domestic law. So my assumption is that New Zealand there'll be greater references and more helpful references to these treaties in New Zealand than in Australia, which is more like the U.S. in terms of not incorporating most of the treaties. What I gleaned from the interviews in Australia is that there are more judges who are hostile to human rights arguments, so you have more of that feeling that if we invoke it, we better be sure we have other arguments, other strong arguments, because otherwise it's going to hurt our clients. New Zealand less so. In fact, I talked to one New Zealand lawyer who had also been a tribunal judge, and he said sometimes the judges have to encourage the lawyers to make human rights-based arguments. So that's a complete role reversal.
Quick follow-up. Could you relate that, especially in the case of Australia, where they haven't recognized Aborigines properly and won't follow human rights law? Do you see the link there with the judges being so hostile towards human rights law, considering the fact that they don't recognize some of their claims?
Yeah, definitely. I think that could certainly play a role, and it's something that we'll certainly look into when we do some background research on, the judiciary's role in Australia and the Aboriginal population. Yeah.
You go.
I should mention, I'm a judge, so I'm just trying to, only in the UK, but I am involved in an international association of refugee law judges for going quite some time, and has quite a lot of excellent Canadian judge members. But my question is really, do you mean to imply that there is or could be or should be an alternative? Because, I mean, international refugee law generally, the human rights approach is the dominant approach. There isn't really a non-human rights approach in any clear-cut way, or if there is, tell me what it is. I mean, the UNHCR will sometimes say they don't entirely agree with the human rights approach, but they broadly say we should build on human rights. And certainly in the countries that you're talking about, including Canada, I don't think you'd get a judge to stand up and say, hand on heart, I am not going to apply a human rights approach, because he or she would know that they would be shot down by their own judiciaries.
Right.
And in Europe, the whole thing doesn't make sense anymore, because it's not as if it's a question of fashion or option or choice. Since the EU Qualification Directive came into force since October 2006, judges, all decision makers had to apply human rights approach. Definition of persecution set out in Article 9 of the Qualification Directive. You can go wrong in law if you don't apply it. So what is this non-human rights approach, or perhaps you don't mean to imply that?
Yeah, you're right that obviously that there's a human rights basis to the right to claim asylum. I mean, it's based on a refugee. I'm sorry, on a human rights treaty, the Refugee Convention. I think the human rights approach that's been advanced by Hathaway and Anchor is, I think, the idea that the human rights, in a sense, it's a broader human rights approach. It's arguing that other human rights instruments besides the Refugee Act and the in some ways narrow definition of what it means to be a refugee, that definition should be informed by other human rights instruments. And so that led me to look at some of these other treaties and to see what impact they are having beyond the basic human rights treaty that forms the right to claim asylum, which is the Refugee Convention. So you're right, there already is a human rights norm or a human rights approach to asylum, to the extent, I mean, the right to claim asylum is a human right. I think part of the argument there is some of the scholars in this area are disgruntled because they feel that asylum isn't afforded the same status as other human rights, the right to be, the free speech or other political rights. Etc. And that asylum has been called the poor stepchild in the human rights paradigm. And so I think part of that human rights approach is to elevate the status of asylum law as within, as a type of human right. But you're absolutely right. It is a human rights based analysis. I think the idea is to sort of broaden the category of rights that come to bear, the category of human rights that come to bear when we're talking about asylum.
Is it a very short one?
Not really, but let me try formulating it shortly. But, well, thank you very much, Steve. This is just fascinating stuff. As one could expect, my question would be a bit broader, so that's why I'm sure it's going to be short. But let's go. What is striking for a non-lawyer here, of course, is how judicialized the area of asylum cases, asylum was become. And, of course, I'm bit influenced from the Swedish side of things here, and one of the reasons behind the decision to bring asylum cases into the judiciary, to set up the administrative judicial system, was to depoliticize the area of asylum politics, really, and to provide an administrative framework and predictability for these cases. That was the rationale. To provide legal security for asylum seekers and so on and so forth. But of course, as striking you mentioned at the various points here is, of course, that it's not an area that's deeply inside. To the contrary, it's highly politicized. And from the case that you mentioned, the Canadian minister signaling to the judiciary effectively what they should decide, and they duly followed in terms of denying Mexicans, denying Roman population asylum. So my question here really is a broad one, and of course you can't respond to this here and now, is really whether this has anything to do with the intrinsic features, intrinsic character of international human rights treaties, international human rights law, or for that matter what lawyers actually do in terms of presenting their cases, or to what extent the factors that lie beyond that, but of course are intimately connected with regards to government policy groups that lobby around different asylum groups in particular, play into this. So what is striking, of course, in a list of factors that you mentioned at the beginning is the absence or only indirectly influence of political factors in government policy and the relationship, for example, between the judiciary and judges operating in this field and executive policy. And these type of relations are not very neatly captured in variables such as ideology or gender, of course. So again, to what extent does this aspect of highly influential aspects of these cases play into your analysis of international human rights treaties? Now, I think it matters in some respect because
we've had a few questions.
Okay,
the question I think is one about to what extent are political factors relevant as opposed to purely
Well, I'll answer that one first, and then we can talk about. Yeah, I mean, they certainly influence it. It's an overlay, I think, and one that I would need to be quite explicit about. There's been a lot written about sort of the rule of law and asylum decisions in asylum jurisprudence in several of these countries, and where people look at exactly what kind of factors that you're not in terms of their influence on the way the treaties are handled, but just on the process generally. And it is, whether it's ideology of the judges, whether it's the way that the asylum system is constructed, and there are ways that, and this goes to an earlier comment, that just barriers to even making claims, obstructions to that, even making it difficult for somebody to get through the courthouse door, so to speak, that are reflective of some of the political considerations. And so, while they may not, as I say, you can't identify them, through case coding per se, I think they're an important part of the equation in each of the countries and impact, the picture of asylum jurisprudence differently in each country, and that certainly needs to be acknowledged. It's not like there's a clean slate that we're looking at with respect to treatment of treaties in each of the countries. So yeah, that's an important point. How to integrate it all into this kind of study is a challenge.
Good. Well, thank you very much again, Stephen, for
thank you.